Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. You'll see it runs through people's faces. Well, we shouldn't be live.
We might be.
We might be. Hey, Deja, you got to let me know if we're live. I can't tell. Should be comments here, but we are live. Okay. Well, in that case, we're caught by surprise. I was waiting for our countdown video, but we didn't have it. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Each Friday morning, typically, but not this week, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. This week, we are streaming live from ILTACON. I've got 14 of these things to do over the 4 days. We're in day 2. I still have a voice left. That's good. Past episodes are available in the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. My guest for this episode is Bobby Malhotra. Bobby is of counsel at Munger, Olson, and let's start with congratulations.
Thank you very much, and thank you for having me on today and taking the time out. I must say, spend a minute on this. You've been a visionary in the field, a mentor for me for many years when I was a baby lawyer. So I can't tell you how much it means to kind of be here and talking with you this morning. Thank you. Thank you for everything you've done for our industry as well.
Glad to have you here. So, rather than talk about my background, let's talk about your background. What brought you to where you are today?
Well, I can state the obvious. I have a kind of a technical background. I was a programmer, network administrator, and then I stumbled into law. And everybody said, this is how you merge the two. It was the perfect marriage. And I'm the model kind of prototype attorney to be an eDiscovery lawyer. But I think it definitely goes beyond that. I really have a passion for the industry, the eDiscovery space that we're in. I look at discovery, when you talk to most litigators, unfortunately, the sentiment is that discovery is a necessary evil. I do it when I have to do it. I don't think about it otherwise, and I don't really like doing it.
Right. It's a chore. It's a checkbox. It's something you need to get past so you can do your real work.
Exactly. And the way I look at it is a little different. I mean, I look at discovery as an opportunity, right? One, it's an opportunity to ensure we're controlling costs for the client.
Right.
We're negotiating a proportional scope of discovery, right? We are in there kind of doing things in a manner that's efficient, strategic, and thinking big picture. And that could translate into hundreds of thousands or millions of dollars of cost savings, right? So if you kind of think about it from that perspective, it's tremendous in terms of the value add that you have to the actual merits of the litigation, because discovery is not cheap. The other opportunity is obviously to get the evidence that you need from your adversary to support the claims and defenses of your case. A lot of times you're not thinking about that. You don't take a step back and see, why am I doing all of this? And what I'm producing, is it in line? Does it have a nexus to the claims and defenses of the case? And am I getting what I need to ultimately try the case, right? So you can see just by the way I'm talking about it, I have kind of a passion for it. And it goes beyond just having the legal background, the tech background. It's really, truly having a passion for the space and the industry and the practice as a whole.
How'd you end up at Munger Tolls?
So I was in the space for a couple of years before I went to Munger. I worked for a couple of top tier eDiscovery providers. And the reason I did that was a lot of firms didn't have eDiscovery lawyer positions. This was 2005, 6, 7.
Yeah, there were no
eDiscovery lawyer positions.
Yep.
Early 2008 hit, and I wanted to make a move out to a firm. There were positions being kind of offered at that time, and I interviewed at Munger. Beautiful LA, great firm, opportunity to actually hit the ground running as a green lawyer at the time, very green. But I kind of took that and kind of ran with it, and I've been there for about 15 years since.
And you have a new role. The comment about congratulations at the beginning. Talk about that.
Thank you. So I recently got promoted to of counsel and co-leader of the eDiscovery and information governance practice group. So what that entails is, in addition to my current practice, which kind of involves navigating complex eDiscovery issues for high stakes bet the company litigation and investigative matters, I now have an additional component to basically set the strategic vision for the practice group, to set the business plan for the practice group, and kind of determine what areas we want to grow and where we want to be, looking out a year, 2 years, 3 years from now. And one example of that is, kind of an area that we're looking to add on to is the discovery counseling practice. Today, I serve as trusted advisor to a few of our large technology and financial services clients. And in that role, George, it's kind of outside of the courtroom, non-litigation, non-investigation context, where I provide guidance regarding standardized eDiscovery information governance and data management practices. I look at it really, the reason I want to grow it out, it's really a win-win for our clients and our firm. When I say win for the client, it's really an area where they need guidance. Things are changing so fast, new and emerging data sources, laws that are not clear or that are very fact specific, right? Possession, custody, and control. What does that mean? What jurisdiction are you in? Is it practical ability? Is it legal right? You couple that on with the challenges of preservation. What are your duties? What are the triggers? It's kind of unsettled. It's fact specific. And now you have these new and emerging data sources on top of that. And things become very hairy and challenging for clients. So they're coming to us to kind of help us or help them come up with a eDiscovery and information governance program, develop or revise their programs, and provide kind of thought leadership and strategic guidance on these hairy issues or these thorny issues. But when the client actually gets involved in a large scale litigation and they retain Munger, they retain our firm, we use that knowledge to tackle discovery in the most strategic, cost-effective sense. We know the infrastructure, we know the policies, we know the practice. It's almost like force multiplier. You're there on day one and you kind of can get right into it. You're thinking about scope, you're thinking about strategy, you're thinking about how you're going to approach things with the judiciary, with your opposing counsel, and you know where the information is. So I think it really adds kind of a win-win for the client because you're providing services in a much needed space, and then for the firm because it makes it easier when the firm is retained for large-scale litigation.
I think it's pretty common in firms if they have eDiscovery expertise, for that to be limited to a handful of people at the most, and for it to be very isolated so that many of the attorneys in the firm don't even necessarily realize there is that expertise there. It sounds as if yours is a different situation from that.
No, I think we do struggle with that. We're a bit smaller of a firm. I mean, think of this as, we're an am law firm, but we're still 200 attorneys. So we're in some respects boutique in certain aspects. But it is a challenge of educating, kind of the larger attorney group within the firm. That is one of the roles that I have with my new position, to kind of let them know in terms of the work that we're doing for these clients, how we may be able to help some of their other key clients, and kind of letting them know and educating them on how we may be able to help, not just in our discovery counseling practice, but actually when there's a litigation and a large matter for that same client, we understand the infrastructure and whatnot. So there is a little bit of education component. I can say it's challenging because things operate sometimes in the legal field in isolation. That's
Right.
just sometimes the way attorneys operate.
Yep.
I'm trying to break the mold a little bit and trying to do my, kind of outreach to our firm attorneys, letting them know about the services we're offering and what we're doing. So hopefully it'll make it a little bit easier. We have 3 offices, so it's not like I have to travel to 28 offices to kind of educate.
Yeah,
people.
that's good. So what does that practice group, the eDiscovery and information governance group within the firm look like?
So right now it's 2 attorneys at the letterhead or kind of leadership level, Kathleen McDowell and myself.
Mm-hmm.
And we're supported by a host of litigation support professionals. These are attorney project managers, attorney eDiscovery counsel, litigation support specialists that are wizards at manipulating data and kind of helping us on the back end.
Mm-hmm.
So that's kind of the support structure today. My hope is very much as we get in and we establish new relationships on the discovery counseling side in the future, that we'll be able to grow beyond the 2 kind of lead lawyers at the firm today who practice in this space.
Part of what you're doing in this practice is using AI. What sort of novel things are you doing with AI? How are you integrating it into your practice?
So to me, the sky's the limit for AI. I think we've just began to, unfortunately, because I think AI has been around for a while, but in the legal industry, we're slow adopters, as you know.
Mm-hmm.
So I think we've just started to scratch the surface in terms of what AI can do and how comfortable the attorneys are, clients are, as well as the judiciary when it comes to AI. Me personally, I try to incorporate AI in just about every facet of my practice, eDiscovery and out of eDiscovery. So to give you a couple of examples, I use it in the M&A context, right, where we are representing one of the transaction parties and we want to keep from disclosure confidential documents from going to the other side of the counterparty. We build an AI model for that. I work with financial institutions, building models to help them comply with anti-money laundering, non-disclosure laws.
Mm-hmm.
We are building models in the context of everyday business when it comes to technology companies, using AI to identify and corral their secret sauce type documents, so their technical documents, their process flow documents, and source code type documents. We're using it with energy companies, right? Their energy companies, oftentimes their business plans are very confidential, and they want to be able to classify this in the ordinary course. So we're using it there.
Mm-hmm.
In the compliance world, we're kind of using it routinely on a daily basis. There's some form of AI being used to help with antitrust reviews, employment compliance reviews. So it's being used across a plethora of different verticals. And I want to see it, because I think it's just the sky's the limit. I said it earlier.
Yep.
I think it can be used in so many different facets. Anytime you have an information governance challenge or a data challenge, you should think about using AI. I really think that we should flip the switch. And, the notion's always been, why should I use AI? Well, I think it should be, why should I not use AI? Give me the compelling reasons why we shouldn't use it to at least supplement and enhance the process.
When you build an AI model, what does that process look like?
I think it depends on the challenge that you're trying to solve, right? I mentioned in the M&A context, we built a custom model with data scientists, not an off-the-shelf, an actual custom model to identify those confidential documents. Training process looked a little bit different there, but it's similar in a lot of respects in terms of identifying training documents, going through seed rounds, understanding and validating what the AI outputs are, and getting comfortable with the process, and then building some kind of validation step to it. So I think that those steps are really common depending on whatever AI model you use, but there might be tweaks depending on what you're trying to solve, right? If you have an adversary and you're dealing with an active litigation, you might have to take some additional steps in terms of documentation and validation, and obviously explaining to the other side in the judiciary in terms of what you're doing. In the M&A context, we really didn't have that, so it was a little bit different. But that training process usually looks very similar. You got to have some way of building the model, establishing the initial learning and training for the model, and then enhancing it to the point where you get comfortable. And then at that point, kind of validating the results.
What has client reaction been to this?
Very positive. I think it depends on the client. There's some clients that, aren't used to this. It's a brave new world for them. And our approach is a little different. We don't want to go all in on AI in day one. We can take it in baby steps. We can kind of tell them the value proposition. We can carve out discrete aspects of a certain project, use AI there, tell them the ROI, get them more comfortable with it. For example, in the M&A space, though, that was a technology client that was very tech heavy, cutting edge industry, Silicon Valley. And it was a much easier sell. And at the end of the day, they were very happy because there was no way for them to be able to shield these confidential documents from the counterparty without using an AI solution. Traditional search terms were not working. It wasn't, it wasn't an option to review 20 million documents, right? Certainly.
Right.
So they were very happy with the outcome in that. But I think the approach, George, really depends on the type of client you're dealing with. And my mantra is always, if it's a new client, they're not used to it, baby steps, explain the defensibility of the process, talk about the potential cost savings, because that really resonates well with clients. And then from there, expand. If things are successful, continue to expand. You don't have to do a completely automated approach on day one. You can always take things in small baby steps.
So clients are part of the equation, but so are opposing counsel. How do you work with opposing counsel to facilitate the use of models in litigation?
So I think that's an interesting question. I think at the very set, you should set, kind of have in your strategy how you are going to negotiate the scope, what kind of disclosures you're going to make to opposing counsel, being transparent in the process, George, but not being so transparent that you need the other side to sign off on everything you do. I'm a strong believer
I like
in advocate.
translucency.
Exactly. I like that terminology. I'm a strong believer in, Sedona conference principles around, the producing parties in the best shape to kind of best position to determine their culling, review, and production workflow. And, I think it's a kind of a fine balance in setting it up early on. So you're building a record of transparency, but you don't set a record that where you have obligations where you have to be too transparent, or you set up a workflow that's too burdensome, which ultimately, because of that workflow, you deem that you're not going to use AI because it's just too burdensome, right? So I think it requires a careful balancing act, as well as attorneys who can really explain this and advocate the position to the other side and the judiciary if it comes down to it.
So let's move to the judiciary. There too, not all judges are comfortable with the idea that AI is going to be used in a matter that they're overseeing. How do you most effectively help judges understand what you're doing and why it's valuable?
What I can say to that is not just in the AI context. I've seen this too often. Lawyers using too many acronyms and being too tech with judges, right? Thinking, and a lot of times these are non-technical lawyers, just using acronyms that they've heard and picked up on the street and using it in the wrong context. I mean, it's funny. I've seen this in discovery conferences before where the adversary, the attorney's just using it, the acronyms in the wrong out of context. But I think it's, you got to distill it down to the proper terminology. You don't want to over tech things. When it's needed and you need support from an expert, you should do that. You should provide that, obviously, in your briefing papers. But when you're explaining things to a judge, you want to be as simplistic as possible, avoid the acronyms. And, it really goes back from day one. Set the proper transparency, strategy, proper disclosures. That will kind of go a long way with dealing with the judiciary. And I'm not saying, in every case, the judge is going to be okay with it or not pose hurdles. But I think more and more judges are accepting. I mean, it's been several years since Judge Peck wrote his series of opinions, rubber stamping AI and the use of AI. Unfortunately, we're not as far as where we should be, but we're moving very slowly, too slowly for my liking, but we're moving slowly in the right direction.
At least we're making steps.
We're making steps. Yeah. I mean, think about it. Over the last, we've been talking about AI at conferences now. I mean, I've been in the industry for 16, 17 years. And we've been talking about AI since I started as a baby lawyer.
Yeah.
And really what it seems to me is that the steps that we've made in the last 2 years, and that, that's because it's becoming a buzzword, obviously, but there's companies like Reveal and other companies that are putting their money where their mouth is and building these unique and powerful AI tools that are push of a button that allow lawyers to use this without that black box stigma.
Yep.
And I think that's helping the advancement of AI. So really, it's unfortunate because 15 years ago, we were talking about a lot of these issues and we haven't come that far. But if you look at what we've done in the last 2 years, since the pandemic even, I think we are going in the right direction. So I would tend to agree with that, but not fast enough.
Never fast enough. One other group then are government attorneys. The regulators, the DOJ. Do you deal with folks like that?
I do.
Yeah.
I mean, and with the regulators, I mean, they have their own kind of, very detailed protocols. A lot of times, if you're thinking about kind of deviating from that, the best, I urge transparency in that respect.
Yes.
But yes, I mean, I think that the regulators have developed their own custom protocols. Sometimes they are onerous in terms of the requirements they pose on litigants or on parties. But a lot of times you kind of got to abide by the rules when you're dealing with a government agency. It's a little different, when you're dealing with an adversary in litigation,
right?
And you can go to the judge for relief, right? Here, it's,
there
you
is
want to
no
be very
place
careful
else
with the
to
regulators,
go.
right?
Yes,
right.
yeah. So part of your practice is eDiscovery. Part of your practice is information governance. Historically, information governance has been starved for resources and pushed to the back of the queue because other more pressing things take up the space. Has that changed? Is it changing? What's happening there?
Is it changing? Yes. Has it changed? No. I think people, senior attorneys are realizing the importance of the practice area, but it still hasn't become kind of a main focus for a lot of firms, right? It's still, unfortunately, in a lot of circumstances, will take a backseat to the primary litigation that the firm is kind of handling. So, there are always going to be, there are struggles when it comes to resources, but I think we are heading in the right direction. I think that firm leaders all over the country, certainly in my firm, are recognizing the importance of this area and are now becoming open to investing in the resources, investing in the lawyers, and understanding how that will help them, not only for the little bit of revenue you get, because it is going to be, no matter how the way you look at it, when you're talking about hundreds of millions of dollars or billions of dollars of revenue, it's going to be a small piece, but just the value add that you provide the client. You make the client happy in a lot of respects. You're providing a service that they are struggling with. And then, like I said before, when you become an expert of the client's data, you just have that strategic advantage. It makes it so much easier when you have to get into that large-scale litigation. If you already know where all the sources are, where the potentially relevant information resides, which business groups you have to talk to, you've already developed. I mean, in the context of my discovery counseling practice, I build relationships, cross-functional relationships across my client's organization. Not only am I talking to the eDiscovery context, but I'm kind of developing friendships with data privacy, export control, the business line lawyers who are dealing with kind of these issues on a daily basis. So it's kind of a broad spectrum of understanding the data, knowing where to go, which just helps the firm in a lot of respects when you actually get into that large-scale litigation.
Well, it sounds as if you have a significant advantage then, because you don't come in necessarily cold. You've got a lot of experience, a lot of background. You understand the organization. You know the people. And that gives you an opportunity to maybe move IG a little farther along than otherwise would happen.
That is actually the goal. Yes, and that's why I'm looking to, like I said earlier, I have a couple of clients where I'm doing this. I want to expand that practice at the firm. You did mention the resource issues. Obviously, we can't, we don't have a group where we can do it for every client, but I want to start with key strategic clients and kind of build that out, because it makes it so much easier. And when I said win-win, it's a win for the client, right? Because you're providing these services that they need. It's a win for us because it makes it easier. And at the end of the day, it's a win for the senior partners at the firm, because they look great in front of the client context and they're doing things in a very efficient manner. They don't have to spend the first few days on a learning curve and understanding where the client's data is, what the retention policies are, how are they handling kind of BYOD devices or ephemeral data sources, and these tricky issues. We kind of know that early on because we've helped the client develop the policies in that regard.
Right. So you have had quite the voyage these past 17 years.
I have.
For folks starting out and saying, I want to be Bobby, how do they accomplish that?
I think the first piece of advice I would give them, it's not an overnight deal. I mean, you really need to put in the time and effort. We are at a very exciting place in our industry where, I say this all the time, it's not my father or mother's eDiscovery or my grandfather's eDiscovery. We thought at one point, we got email data conquered, we're good. Right?
Yeah.
We're going to retire. We don't need eDiscovery lawyers.
Yeah.
That's far from the truth, and it's going to become even more challenging as we go on. And new apps are created with new retention policies and encryption policies, and just dealing with the cross-border issues between transferring data from one country to another. There's so many issues that you could be dealing with, and they're becoming more complex. So the advice I would give, it's not an overnight process. You have to be a student of the game. I'm a student of the game, and I don't mean to invoke the sports metaphor, but that's how I am. It's a learning experience on a daily basis. There's no way you can know everything about everything, right? You got to know enough to spot the issues. But in order for you to know enough to spot the issues, you really got to put in the time and effort, and really have that passion. It's not just about a job; it's a career. It's something you have to have a passion for. But I do think that there's a lot of opportunities out there for people to progress, as long as they put in the work, and they have the passion, they have the drive.
Before we got on this podcast this morning, you were talking about some of the challenges and maybe opportunities with respect to the metaverse. Care to expand on that?
Yeah, I saw. I mean, I was in attendance at the excellent presentation that Kat gave and others yesterday. And I've been thinking about this for quite some time, right? As the metaverse expands, you're creating personal data at an unprecedented level, right? Personal data that can be traced back to individuals via their user ID or some other characteristic. We're already struggling with cross-border issues when it comes to eDiscovery, kind of on a daily basis, right? Where we're trying to determine, where is the data? Does it reside in a country where you have a data privacy law? What does that data privacy law entail? Can we export the data? Do we need to come up with alternative mechanisms, such as reviewing in the local country or redacting? We're kind of thinking about all of these things. Now, on top of that, you add in all of this private data that's being accumulated in various parts of the world. It just adds so many challenges to the process. What type of data is it? Do we, can we classify it? Whose data is it? So it just opens up a world of additional opportunities and job security for eDiscovery lawyers. But at the same time, it poses a lot of challenges. And I really do think in 5 or 10 years, as we see more of this acceptance of the metaverse and those types of things, the Web 3.0, we're going to have to rewrite our eDiscovery checklists and our workflows to account for that in witness interviews, to account for that in our Rule 26 disclosure. I mean, there's just so many implications when you think about that.
Well, Bobby, thank you so much for stopping by. Bobby Malhotra is of counsel at Munger, Tolles & Olson. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Bobby, thanks again.
Thank you so much. Pleasure to be here.